privilege to welcome you all to technical session 2 of the National Conference on Indianization of the Legal System.
Today, we stand at the cusp of transformation. This is more than a gathering of minds. It is a collective step towards shaping the future of justice in India. Our focus for this session is as profound as it is timely: criminal law. But through a revolutionary lens, we will delve into three landmark reforms that promise to redefine the legal landscape of our nation. The Bharatiya Nyaya Sanhita, which seeks to reshape substantive criminal law with more victim-centric and justice-oriented approach. The Bharatiya Nagrik Suraksha Sanhita, aimed at modernizing procedural safeguards and enhancing citizen safety. And the Bharatiya Sakshya Adhiniyam, a forward-looking reimagination of evidentiary law to meet the needs of the digital age. So let us not just observe history today, let us participate in its making.
We now kindly welcome Dr. Pooja Deswal, Dean of Academic Affairs, Dr. B.R. Ambedkar National Law University, to deliver the welcome address.
A very good afternoon to the dignitaries on the dais. Shri Inderjeet Mehta ji, Member, Haryana State Law Commission. Professor Dr. Anju, Tikoo, Vali, Dean Faculty of Law, University of Delhi. Professor Dr. Vageshwari Deswal, Professor, Faculty of Law. And Professor Dr. Asad Malik, Professor, Faculty of Law, Jamia Millia Islamia University. So today, when we are talking about Indianization, this session, which talks about the new criminal laws, is one of those sessions, because all other things we're just saying. But these are the three laws where we could see that how the morals, ethics, as we have been talking since morning, which is a part of our Bharatiya culture, how they have been imbibed, how the community service has been brought into. And it is Nyaya Sahita. It is talking about justice, not about penalizing. And I welcome all the resource persons. And if you look at the panel, we have one of the resource person is from the Law Commission, who play a very important and a vital role when it comes to drafting of the laws. And then three resource persons from the academic end, which primarily profess and teach these laws. Apart from this, the faculty primarily help the students to brainstorm and develop a sense of understanding towards these laws. So without taking much of time, I welcome all the four resource persons, and I further look forward that the deliberations in this session would help the students to develop an understanding. And as these three laws are part of the curriculum from this academic session, so how they would learn a little more, because it's just the beginning and a long way has to be gone. So thank you so much. And now I would request the resource persons to share their inputs. Thank you so much.
Thank you, ma'am. Ladies and gentlemen, this technical session focuses on Indianization of the legal system, not just as a reform, but as a revival of values, languages, justice systems rooted in our soil. it will explore not only the statutory changes, but also the philosophical shift towards a justice system that speaks our language, understands our realities, and upholds the ideas of Swaraj and Swabhiman.
With these thoughts, we now begin our journey of dialogue and discovery. And to commence with this meaningful session, ladies and gentlemen, it is with great pleasure that we now invite a distinguished academic and a speaker whose contributions to the field of law are both vast and invaluable. It is our honor to welcome a very special guest to share his thoughts with us, a prolific speaker, a keen observer of law in society, and someone whose insights always strike a chord. Please join me in welcoming Professor Dr. Asad Malik, Faculty of Law, Jamia Millia Islamia, New Delhi, as our esteemed special guest for the conference. We now welcome Sir to address this session.
Thank you very much. Honorable Justice Meenakshi Mehta, Professor Anju Vali Tikoo, Chair, Professor Vageshwari Deswal, Shri Inderjeet Mehta ji, Dr. Ashutosh Mishra, Professor Devinder Singh, Varun, and all dear teachers and students. First of all, I would like to thank Dr. Bhimrao Ambedkar National University for giving me this opportunity to attend this session and to share my views on the new criminal laws. And I congratulate the university for organizing this wonderful program, Dr. Ashutosh Mehta and Vice Chancellor and all the faculty members. So actually, I am going to deal with this Bharatiya Nagrik Suraksha Sanhita. As all we know that since the morning we are discussing about the Indianization of the legal system. And we know that in our country, when this new criminal laws was passed by the parliament in 2023 and which came into force on 1st July 2024. But before this 1st July 2024, when we will see and go back in 1833 charter when issued, and Lord Macaulay came here in India and the first law commission was constituted, and then the work of the codification was started. And as all we know, there are three courts, first three courts, 1859 CPC or 1860 IPC and then 1861 CRPC and 1872 Indian Evidence Law. But if you will see the IPC, which is now replaced by the Bharatiya Nyaya Sanhita after 163 years, and then this Indian Evidence Act has been replaced after the 151 years. And so far as the CRPC, it was already replaced after 112 years, and again it is replaced after the commencement of the Constitution after 50 years. As all we know that when the Constitution of India came into force, then the 6 law commissions, 32nd Law Commission, 33rd Law Commission, 34th, 35th, 37th and 41st Law Commission report were submitted, and finally the CRPC was made. And now, because keeping in view the advancement in the technology, and also as we discussed in the morning that the workload before the case court and also the overcrowded prisons. So if you will see the Bharatiya Nagrik Suraksha Sanhita, the main focus of the legislature on 2 points basically. Number 1, that timeline has to be fixed, or number 2, that is the use of the technology. So if you will see from the definition point, first definition that has been added, audio, video, electronic means. And then electronic communication has been defined. Also they try to remove this some of the metropolitan magistrate or assistant session judges from the hierarchy of the courts. And also one of the addition in the hierarchy of the public prosecutor in terms of the assistant public prosecutor. And best thing which is done, that is the responsibilities and powers has been discussed in the Bharatiya Nagrik Suraksha Sanhita, particularly with respect to the public prosecutor. But now we are coming on the main points and keeping in view why these changes have been made. What was the reason? वो कहते नहीं है कुछ तो मजबूरियां रही होंगी, यूं तो कोई बेवफा नहीं होता. अब क्या मजबूरियां थी? So we have to see the reason. Actually, I am starting with one of the judgment of the Varun Bagga versus State of Punjab. That is 2023. Actually, this decision where the High Court said that there is a misuse of the registration of FIR, means the process of law is being misused. What happened in this case? In this case, the court said to satisfy her ego, that girl first slapped in public the boy and then registered the FIR and entered into the compromise and then claimed 1 lakh rupees. And then 482 petition was filed for questioning the FIR. So court discussed this is the taxpayers' money is being used only to satisfy the ego. and the satisfaction of the ego of the one person but the life of the other person, because Article 21, no person shall be deprived of personal life and liberty except according to procedure established by law. So now when we will see under the 173, the concept of the preliminary inquiry now has been incorporated. If you will see the 173, the three main changes has been made: number 1, 0 FIR, number 2, AEFIR, or number 3, preliminary inquiry. Actually, preliminary inquiry was not new. In 1964 judgment, the Supreme Court said it is in CRPC there is no provision which expressly conferred the power of the police officer to conduct the preliminary inquiry. But as we know, the Lalita Kumari judgment with the specific 5 points that has been given, where the preliminary inquiry was only allowed to see whether this is a cognizable offence or not. But now, in present time, only the purpose of the preliminary inquiry under 173 to see whether there is a prima facie case exists or not. Reason is that the power is given to the magistrate under section 173, read with section 175 class 3, where the term may, the magistrate has power under section 175 to order the investigation. This may term is a discretion, but the court again and again saying the discretion should not arbitrarily be used. And recently one of the judgment delivered by the Honorable Supreme Court, that is one of the best judgment, Om Prakash Ambedkar versus State of Maharashtra 2025, where the court discussed there is a need to follow the procedure. Actually, the purpose is only to incorporate those unnecessary, the people should not be harassed and they should not become the victim of the system, because once the FIR is registered, all we know what are the problems faced by the person. So this is one of the very good addition, or that is beneficial, and number of the judgment recently delivered by Honorable Supreme Court on that particular point. On the other side, as I am citing another judgment, Naval Day Bharti versus State of Uttar Pradesh 2019. And because of that judgment, I think the addition, that is section 223 class 2, that is again good. However, it is being criticized by many people. What is this 223 class 2? 223 class 2 is saying the provided that the magistrate will not take cognizance without provide the opportunity of being heard. However, sometime it is to be said, Devendra Pandey versus State of Odisha 2005, where the court said at this stage the accused person should not be allowed to give this any kind of the explanation or the defense, otherwise there will be a mini trial. But what happened Naval Day Bharti? In this case, one of the girl who appeared in the examination, in UPSC examination, she appeared in the examination, submitted all the sheets, but one day she received one of the summon that you have run away with your answer script, so case is registered against you under section 3/10 of the Examination Act 1981. FIR was registered, submitted, charge sheet submitted to the magistrate, magistrate issued the summon. When she approached to the High Court for questioning of the summon, it was found there is, पहली बात कोर्ट ने कहा कि she said that I appeared in all the examination, I duly submitted by answer script, but most interesting thing, it was found there is no law in India in the name of the Examination Act. And the law was the FIR registered, charge sheet submitted, cognizance issued. Then the court said it is very unfortunate, mechanically the magistrate issued the direction, and it is a clear-cut violation of the Article 21. So if you will see this kind of the application of the mind, so that will be better that section 223 class 2, and now the High Court said it is mandatory. Means the term shall is used under section 223 and it is mandatory for the magistrate to provide it. And one most important, another important provision, वो कहते नहीं है क्या गम है समंदर को बता भी नहीं सकता और आंसू की तरह आग तक आ भी नहीं सकता. When a public servant who is performing the duty, he needs some kind of the protection should be provided to him, because many people, because of ill will and many reasons, try to target him. There was only provision in the CRPC was section 197 that no court shall take cognizance if any complaint filed against the public servant, judge or magistrate. Otherwise there was no. But Anil Kumar Appa case 2013, the court said under section 156 class 3, the magistrate cannot issue any direction for the investigation without the prior sanction. But now under the section 175 class 4, it is clearly incorporated that if any of the complaint filed against the public servant, then number 1, the report of the senior officer should be sought, or number 2, the assertion of the public servant should be taken. And in the case of the Om Prakash Ambedkar, the court clearly said that if any of the complaint filed against the public servant, the magistrate cannot proceed without following the procedure which is laid down under the Bharatiya Nagrik Suraksha Sanhita. Another important change is with respect to this proclamation. Actually, as we know, there are processes: number 1 summon, number 2 warrant, number 3 provocation, or number 4 proclaimed offender. Earlier the proclaimed offender could only be declared in the 19 sections which was given under section 82 class 4. But now under section 84 class 4, it is clearly written any person who is the accused of the offence punishable more than 10 years under the Bharatiya Nyaya Samhita or any other law. Earlier the term any other law was not there. Rishabh Shetty case, the court said if the person who is the accused of any other law cannot be declared. So this is a good change. But more important change in absentia trial. However, it is to be said it is a violation of fair trial. But no right is absolute right. In the case of the state of Haryana versus Ram Meher, the Supreme Court clearly said a fair trial is not an absolute concept and we are not supposed to play on the whims and the fancies of the prosecution and the defense. So in this case, this addition 356 means in absentia trial now can be conducted. Certain safeguard has already been provided. And one more important thing is that protection to the public servant again unnecessary है. सर ने सुबह अभी किसी ने बताया, सर ने कि वो हाँ देवेंद्र जी ने बताया कि एक मर्डर हुआ और कोई गवाह बनने को तैयार नहीं है. इसी तरह से पुलिस ऑफिसर्स और ऑफिसर व्हेन दे आर परफॉर्मिंग द ड्यूटी दे आर सपोज टू अपीयर एज ए विटनेस. तो पहले उन्हें आना पड़ता था, बट नाउ सेक्शन 336 which has been incorporated they can appear through the video conferencing. तो एक्चुअली देयर आर मैनी चेंजेस हैज बीन मेड. लेकिन लास्ट में मैं एक बात कहूंगा कि सुबह से हम एक बात करते चले, वी आर सपोज टू परफॉर्म द ड्यूटी. Because duty in the sense that no law will work unless the people are honest. And honesty in terms of the agencies, because 5 functionaries are involved. And plus the litigants. Reason is that every time we try to blame the others, वो कहते नहीं है इस कदर है दोस्त जो इल्जाम सुनाई देंगे, हम कहाँ तलक तुमको सफाई देंगे, और जब तक आईने में खुद को नहीं देखोगे तब तक दूसरों में तुमको ऐब दिखाई देंगे, और खुद अगर साहिब मसनद हैं तो सब जायज़ है, और दूसरे अगर हों तो उसूलों की दुहाई देंगे. So rule not only for others, rules also for yourself. Then the person who is going to file the complaint against the other, then you have to think it is your duty not to harass the other person. Because no system, no law can work unless the people are honest. Because as we are discussing since the morning, concept of dharma, so you are supposed to perform your duty. Your duty is to be honest, honest in the dealing with the people, not to satisfy the ego, not to harass the person. And one more important thing, एक्चुअली अभी सुबह जो थ्योरीज ऑफ पनिशमेंट की बात हुई, कम्युनिटी सर्विस सर ने भी डिस्कस किया, दैट इज वन ऑफ द एडिशन. एक्चुअली एज वी नो 5 थ्योरीज ऑफ द पनिशमेंट: एक्सपिएशन थ्योरी, प्रिवेंटिव थ्योरी, डेटरेंट थ्योरी, रेट्रिब्यूटिव थ्योरी, और फाइनली दिस रिफॉर्मेटिव. आई एम टॉकिंग अबाउट 2 ओनली. नंबर 1, फर्स्ट एक्सपिएशन थ्योरी विच वाज बेस्ड ऑन द रिलीजन. कहा जाता है हर धर्म में माफ करने वाला बड़ा होता है पाप करने वाले से. This is the compounding of the offences which has been incorporated in the CRPC. Now we have section 359. वो कहते नहीं मैं अपने दिल को जहन के खिलाफ कर देता, मैं अपने दिल को जहन के खिलाफ कर देता, वो सर झुका के जो आता तो मैं उसे माफ कर देता. तो दिस इज द टेंडेंसी ऑफ द ह्यूमन बीइंग. अब हमारा जो सेटलमेंट का प्रोविजन है टू रेड्यूस द पेंडेंसी ऑफ द केसेस. अब आते हैं रिफॉर्मेटिव थ्योरी, रेस्टोरेटिव जस्टिस. Community service as a form of the punishment has been incorporated under section 4 clause F of the Bharatiya Nyaya Samhita and section 23, which give the power to the magistrate of the first class and the second class to pass the order of the community service. What is community service? Community service means the person can perform the sum of the function for the community without any remuneration. Purpose is that, आपको याद होगा एक जुवेनाइल जस्टिस एक्ट शायद आप जानते हो. If you will see section 15, it was already there. And one more thing, if a person who has been convicted will be disqualified. So that's why there is a provision under the Probation Offenders Act plus Juvenile Justice Act. Section 12 of the Probation Offenders Act, Section 25, that person will not be considered as a disqualified. So if community service as a form of the punishment, so certainly it will be helpful to improve. और इसीलिए कहा भी गया था कि जो क्रिमिनल है उसे आप पेशेंट की तरह देखिए, थेरेपी की उसे जरूरत है, ना कि आप उसे सजा दे दें. वो कहते नहीं है एक निवाले के लिए जिसे हमने मार डाला वो परिंदा भी कई रोज का भूखा निकला. वट एवर द रीजन मे बी, तो वी हैव टू सी. तो फाइनली आई वुड लाइक टू कंक्लूड बाय सेइंग कि these 4 provisions, that is I think one of the best for the use of the technology. Number 1 section 2A, number 2 section 2 clause I, number 3 section 105, or number 4 section 530 considered as e-court. At the time of issuing the summon, warrant, execution, and complainant and witnesses, all the things will be done through the video conferencing. 105, every search and seizure shall mandatorily be recorded through audio video conferences by the cell phone by the police officer, will be forwarded to the district magistrate, judicial magistrate of the first class, and sub-divisional magistrate. तो एक्चुअली द पर्पज इज टू प्रमोट ट्रांसपेरेंसी. तो कहते हैं 3 बातों का खास ध्यान रखा गया. नंबर 1 एक्सेस टू जस्टिस, नंबर 2 ईज ऑफ जस्टिस, और नंबर 3 transparency, to promote the transparency. So this new law, I think that many things have been changed, or certainly we are hopeful that in future that will be very helpful. And one more thing, the government of India already conducted number of the conferences and the programs and training programs for the officials are involved in the criminal justice system, so that they should be well equipped. Plus that infrastructure development, and one provision where there was the doubt that it will not be possible to implement immediately, they give the 5-year time, section 176 class 3, which says that the forensic investigation to be conducted in the offences punishable more than 7 years. However, it will came into force after the 5 years. If one state don't have the facility, then they are supposed to take the facility from the other state. It reflects the concept of the cooperative federalism or collaborative federalism. So finally, I will say that it is one of the good initiative taken by the government and timely taken. In future, certainly it will be beneficial for all, because this law clearly enhance the witness protection plus victim protection as well. So thank you very much once again to the Dr. Bhimrao Ambedkar National University and particularly Asad. Thank you, ma'am.
We extend our heartfelt thanks to Dr. Asad Malik for his engaging and insightful address. Your perspectives have truly enriched us all, our understanding of the topic, and I'm certain everyone present here, whether veteran or no voice, has gained something. We have an announcement. If any participant who is presenting this presenting paper, please move to room number 115, first floor.
It is now our privilege to welcome a distinguished academic and an articulate voice in the contemporary legal discourse, Professor Dr. Vageshwari Deswal, Professor at the Faculty of Law, University of Delhi, as our esteemed special guest for the conference. Known for her insightful reflections, Dr. Deswal brings depth to every platform she graces. Ma'am, we are honored to have you here with us. May I now invite Dr. Vageshwari to share her valuable insights with us.
Honorable Madam Justice Meenakshi Mehta, respected Chair Shri Inderjeet Mehta, Dean Faculty of Law Professor Anju, Professor Asad Malik, the Registrar of B.R. Ambedkar National Law University Professor Ashutosh Mishra, Shri Pawan Duggal, my colleagues, Professor Pushp Kumar, Professor Varun Chachar, Professor Pradeep, Professor Kulwant, Professor Vikesh Tripathi, respected dignitaries on the dais and off the dais, and dear students, good afternoon to all. First of all, I would like to congratulate B.R. Ambedkar National Law University, especially my colleague, who's like a younger brother to me, Professor Ashutosh Mishra, for thinking of such a pertinent theme in contemporary times, and which is Indianization of legal system. Now the theme could not be more relevant than what it is today, and that is because we are about to complete 1 year since we adopted the 3 new criminal laws, and that is the basis of keeping the title of this particular session as, keeping the theme of this particular session as the new criminal laws. For a long time, we've been talking about Indianization of the Indian legal system. And that is something which we need to do. Why? Because we had a robust legal system. We had a robust framework. But that was before we were subjected to multiple foreign invasions, one after the other, and ultimately, when we drove away the Britishers, after that, what we could do? We enacted a constitution. We reminded ourselves that we are in a rights-based framework, a country that guarantees equality to all its people. See, we had to take a lot of time to shed off the colonial baggage, and also the baggage that was thrust upon us by multiple foreign invasions. Slowly taking one step in that direction, but finally we can say that yes, we are now, we've picked up speed, and now we are moving in the right direction. To begin with, we've got these 3 new criminal laws which have replaced the old archaic and colonial criminal laws that were enacted by our imperial rulers. Now the laws which were made by them were made for their subjects, unlike these laws which have been made by our democratically elected leaders for their own people. So that is the reason why when we begin with these 3 laws, the first thing that comes to our mind is renaming of the 3 laws. The titles that inspire confidence in us. See, many people say, what's in a name? And a Shakespeare, what he said? A rose is a rose by whatever name you call it. But let me tell you, there is a lot of thought process that goes behind a name. I mean, tell me, how many of you have got names which have got a very deep meaning? And why do you have these names? Because there was a lot of thought process that your parents put behind naming of you, and there was an objective, there was a dream that they had, that my son, my daughter, my child will, I mean, what do we call it? Will translate the meaning of his name into reality. Apne naam ko sarthak karenge. And that is why when these laws had to be changed, we had to very thoughtfully think of renaming the laws. And that is why Indian Penal Law, Indian Penal Code, a law which talks merely about punishing people, we replace it with Bharatiya Nyaya Sanhita, a law that is committed to providing justice to its people. Instead of a law which merely objectively talks about the procedure that is to be followed by our criminal courts, now we have a law which proclaims security and which guarantees the protection of its people, of our own people. Bharatiya Nagarik Suraksha Sanhita. So it has already been discussed in the morning sessions. Why? Because when we talk about Bharat, many people say that maybe it's a political move. Why did we have to rename India to Bharat? What does our constitution say? Article 1, India, that is Bharat. And then tell me, I mean, so many languages are spoken across the length and breadth of our country. In which language do you find the term India? But there are so many languages in which you find references to the term Bharat. So this is our law, a law which we have enacted for our own people, and that is why instead of India, we've named it Bharat. Instead of punishment, now we have justice, and justice which is complete justice. And why this was important was because in the traditional criminal justice system, punishment to an accused person does not translate into justice for the victim. You punish the accused person. What does the victim get? Although after the Malimat Committee recommendations, we've slowly been developing jurisprudence relating to compensation, which was hitherto restricted only to civil court cases. But now we have this concept of compensatory jurisprudence in our criminal law also, and something which has now been described, which has been inserted in a very detailed manner in the new criminal laws. Then, as we've been talking about community service, see, when we talk about complete justice, so, and we also talk about the different theories of punishment, especially when we talk about the expiatory theory of punishment. See, the victim who has suffered a loss, the accused gets punished, but the victim also needs a closure. So how will you give that closure to the victim? For that, it is important that the victim should also have some sort of a say in the punishment. Maybe the victim is the larger person. Maybe the victim wants to pardon the accused person. So there are these principles of restorative justice, which were there in our ancient Indian jurisprudence also, and slowly we've tried to bring in them in our new laws also. As of now, this concept of community service, it has been introduced on an experimental basis. See, before that, we had this concept only under the Juvenile Justice Act, but now we've introduced it in 6 kinds of crimes, and which are basically petty in nature. Now tell me, suppose there is a woman who's driven by hunger, who's got children to feed, now compelled by party, if she steals a loaf of bread, would any judge have the heart to sentence her to imprisonment? And would that be fair? As a society, is it not us who have failed this woman? So now what does this law say? Earlier, we had the concept of only sentencing. Now, in such cases where the value of property stolen is less than 5,000 rupees, the offender is a first-time offender, the offender is willing to make good the losses or to return the property stolen, then in such cases we can provide community service instead of sentencing the person to imprisonment. Now, how community service would play out, how it would be administered. Now, that is something which we will have to wait and watch. That is something which our learned judges would have to take a call on, depending upon the facts and circumstances of each and every cases. Now, there is one particular incident that I'm reminded of. Now, there's a lady judge in Delhi High Court. Now, when she was in the district judiciary, at that time she tells that once she had gone to Gurudwara Bangla Sahib. How many of you have been to Connaught Place? So there is that huge Gurudwara there, okay? And that's on a very busy road. So there are lots of traffic coming and going there. So she said once she had gone there to offer her prayers, and she saw that there was a group of 7-8 boys on motorcycles, and what they did, they had removed the silencers of their bikes. So what they were doing, बहुत ज़्यादा रेस दे रहे थे, धूं धूं करके इतना शोर मचा करके वो अपनी बाइक को और वो गुरुद्वारे के इधर उधर they were just going around. Now, it was obviously very disturbing for those who had come to offer their prayers. In addition to that, it was a source of threat to the people there and also to the boys who were on those bikes. She asked the policemen accompanying her to round up those boys and bring them in front of her. She said, when those boys were brought before me, she said, I could clearly see that they were not criminals. They were not there to commit a crime. They were misguided youth, and they were there just for the thrill of it. They felt that maybe we would appear like heroic. It was a heroic deed, that what we are doing, they could not realize, and they were not basically thinking in that direction, the damage that could be caused by that. So instead of punishing them, what she did, she deputed a policeman, and he said that you have to ensure that for the next 1 month, these boys, they regularly come to the Gurudwara. One of them will be mopping the floor, पोछा लगाएगा, एक जूते पॉलिश करेगा, कोई लंगर में काम करेगा, कोई कुछ और काम करेगा. And at the end of the month, all those boys, they went back to her. They thanked her. By that time, they had realized where they had gone wrong. So that is the entire objective behind ushering community service as a kind of punishment, so that the people realize that what they've done is wrong. They should not be doing that again. And in doing that, they need to do something which is of benefit to the community at large. Okay, then. This was about the victim-centric concept also, in which we are focusing on compensation. Then special focus on the laws, in the new criminal laws on women. In the morning, Mr. Jha, Professor Jha from JNU, he talked about the Western jurisprudence, and in which largely what is believed is that Eve was created out of the rib of Adam. Okay. So if you removed a rib from Adam, and out of that rib you've created a woman, and Adam is also working just fine. What that implies is that maybe the rib is a dispensable part of his body. So a creature who's created out of a dispensable part of somebody's body, how important could that person be? And that is why when they talk about better half, they are basically just humoring women. They don't believe in this concept. Okay. Whereas in India, we actually believe in this concept. Okay. In India, women, they were the drafters of our Vedas. Okay. औरतें शास्त्रार्थ करती थी बैठ के पंडितों के बीच में. So it is not that the Pandit were only men. Pandit were equally women also. So women were extremely learned. Women had all their rights. And now these new criminal laws, they are again committed to bringing women back to that position. And that is why we have now introduced a separate chapter for women. And that is a chapter which has been placed as the first chapter dealing with specific offenses. See, the initial 4 chapters, they are dealing with preliminaries. After that, when we come to specific offenses earlier, in the specific offenses, the first chapter was related to offenses against the state. And why? Because at that time, it was the state which was the important. But now, the first chapter is offenses affecting woman and child. After that, we have offenses affecting human body, and then comes offenses against the state. Now, does that mean that the state is any less important now? The answer is no. But obviously, no state can be ever more important than the people which comprise that state. And amongst those people also, we have to be mindful of the very vulnerable segment of our society, and that is women and children, definitely who need more protection, because we have a vision, we have a mission. Women, children, they are to be granted equal rights as per our constitution declarations, and we have to bring them back to the same position. Then a couple of points before, because I've been already handed over this chit. So as we say, justice delayed is justice denied. In our old criminal justice system, there was a lot of emphasis on timely delivery of justice. Raja bhi न्याय से ऊपर नहीं था, कानून से ऊपर राजा भी नहीं था, and the focus was that justice has to be delivered in a very timely manner. But because of the due process model, now what has happened? There are a lot of delays. So many a slip between the cup and the lip. So that is again something that we've been trying to correct by introducing specified prescribed timelines in our procedural law, so that justice is not delayed and it is delivered before it's no longer tastes sweet. Then there have been certain provisions regarding ushering in of gender neutrality. When we talk about children, now we are talking about male, female, as well as trans children. Earlier in our IPC, the definition of child was not given. We used to talk about minors, and the age of majority was different for boys as well as girls. For example, if we talk about kidnapping, for boys it was 16, for girls it was 18. Then if we talk about person, now man, woman, trans person, everyone. And rightly so, because we also got the Transgender Persons Rights Act in the year 2019. And what stands testament to our commitment towards gender neutrality is if you look at any of the architecture of our ancient temples, all the carvings and all on those temple walls, and you can see India was a very liberated society. We had laws, and of course, we had laws to regulate that openness of society does not translate into immorality. But when we talk about a draconian provision such as Section 377, now that was something which the Britishers, they brought in our laws. Why? Because they had the Buggery Act. Now there, because children, they had to be protected against sodomy. Pedophilia, that was something which was very, very prevalent in their society at that time, and that is why they brought in 377, which we have rightly now removed. Now a lot many people, before I conclude just this last submission, there are a lot many people who believe that maybe 377 should have been retained in the watered down form, the way it had been done by the Supreme Court in Navtej Singh Johhar's case. So let me tell you, we already have a provision relating to sexual harassment, which was earlier 354A, which is now section 75 of the BNS, which is partially gender neutral in the sense that this is a law which protects both men as well as women against sexual harassment, whereas the perpetrator can only be a man. And then we have provisions such as voluntarily causing hurt, grievous hurt, criminal force assault. So we have to cut the cloth according to the measure of the person for whom the garment is to be stitched or whatever. So I think I have made my point here. So with that, once again, thank you so much to the organizers of this conference, and thank you the audience for being such a patient audience. Thank you.
Thank you so much, Professor, for your enlightening address. Your expertise and insights into the Indian legal system has truly been inspiring. Ladies and gentlemen, we are pleased to welcome Mr. Gaurav Gupta, Director, Cybersecurity Division at the Ministry of Electronics and Information Technology, Government of India, a key figure in India's digital security. He brings with him invaluable insights into the evolving cyber and regulatory ecosystem. Sir, we are honored to have you with us. We now welcome sir to address this session.
Good afternoon, and dignitaries and students. Uh, I'm privileged to be here, and I thank organizers for inviting me. As the topic of new laws is going on, where we have emphasized that any case which has more than 7 years of punishment will require forensic investigation. So I come from Ministry of Electronics and Information Technology. In IT Act, we have a provision of Section 79A of IT Act, which says that government may notify examiner of electronic evidence. So this was something which we started working on in 2014, although the section was there since 2008. So 2014-15 we made a scheme, and now we have a scheme of Section 79A where we notify examiner of electronic evidence. And what we do, we go to forensic labs and we evaluate them in a 3-stage process. And these labs are assessed for their competence in terms of resources, manpower, SOPs, and overall the way they investigate. So once they are notified as examiner, right now we have 16 such labs which we have notified in last 7-8 years. And now many more labs are around 30-40 labs are in pipeline where we are investigating and evaluating them and helping them become examiner of electronic evidence, which will actually help in terms of bringing down the investigation time. So the biggest problem which we face in court of law is the reports which have to come from forensic labs are delayed, and a lot of time is there because the reports are not coming on time. So in cases of cyber crime, especially the digital forensic reports, these labs have been their processes has been streamlined, their SOPs and their guidelines and the way they conduct their training, all these aspects are evaluated before they are notified as examiner of electronic evidence. So as a result of this notification, all those 16 labs, they are now having standardized reports, they are efficient and their reports are coming on time, and a lot of pendency has been reduced. So this is one important step which Ministry of Electronics and Information Technology has taken in terms of speeding up the investigation process in forensic lab. Along with this, I would also like to highlight that we have Data Protection Act, and now rules are being framed, and it is in public consultation is over. So once that is also there, I think a lot of things will change, because right now a lot of cyber crimes which are happening, they are happening because data is everywhere. There is no value of consent and data is being misused. Cyber criminals now mine all kind of data whichever we share in any place, and all these are being misused. So these are again, an area of concern where I think ministry is working on. Then this ministry also offers a lot of internship. So right now, Digital India internship is open. It's there on ministry's portal. So if you go to Ministry of Electronic website, you can see the opportunities in terms of internship, and that also includes cyber law related internship. So if you want to work on areas related to where we have regulation requiring emerging technology, we have artificial intelligence, which has a lot of ethical and ethical issues which needs to be investigated. How do we ensure regulation of the new technology? Because I can make synthetic videos. I can take a video or an audio or a text or image of somebody and can synthetically change and enhance it. So what are rules and regulations, and how the next set of regulation can be developed? A white paper can be written by students, research can be done so that these kind of issues can be addressed. So keeping these in mind, I think there are a lot of opportunities in terms of internship, and I think the last date is 24th April. So maybe students of B.R. Ambedkar National Law University can make use of it and then can probably apply and be part of the internship related activities can also be explored. So there are a lot of schemes. We also have a lot of R&D funding which we give to academic institutes, not only in cybersecurity but various other areas. And then cyber law and evaluating how the Personal Data Protection Act will the impact on the society will be. These are the areas where I think a lot of funding is also available to the academic institutes. So again, the universities can write a research proposal which can help faculties and students take up interesting research problems, the gaps which are there because of the technology and law intersection. So those techno-legal aspects can be addressed. And these kind of opportunities Ministry of Electronics offers. These things that lot of steps are being taken by Ministry of Electronics and Information Technology, and a lot of opportunities are there at the intersection of technology and the law, because that is where rules and regulations are changing fast. That area, because technology changes fast, so requirement of developing new rules and regulation and keeping pace with the changing technology will have a lot of opportunities for all the stakeholders. With this, I would like to say thank you for inviting me in this forum. Thank you.
Thank you, sir, for your powerful and deeply thought-provoking address. Your vast experience and clarity truly enriched our understanding. It is our privilege to now welcome a distinguished academician and an influential voice in legal scholarship, Professor Dr. Vageshwari Tikoo, Dean and Head of Faculty of Law, University of Delhi, as well as esteemed co-chair of this national conference. And for her scholarly depth and impactful articulation, Dr. Tikoo continues to inspire thought and reform through her work in the legal field. Ma'am, we are honored for your presence and now request you to kindly share your reflections with the audience.
Divyanshi or Prithvi for that wonderful moderation of the session. I stand before you keeping in mind the fact that we are already behind schedule and each one of us is more keen to know about the theme of the conference, which is Indianization of the legal system. And before I get into my address or some observations as co-chair, first the protocol demands. Shri Inderjeet Mehta ji, chair for the session. Madam Meenakshi Mehta, the judge of High Court of Haryana and Punjab. My co-panelists here, Professor Vageshwari Deswal, Vageshwari, Professor Asad Malik, Asad, Shri Gaurav Gupta ji, and my dear colleagues, Professor Push, Varun there, Prem there, Balwinder ji, and last but not the least, I believe, Ashutosh Mishra, with his elaborate team, and of course, the Vice Chancellor, Shri Ashok Kumar ji. It is indeed a moment of thinking that why we have gathered here. For the past 1 year, there has been a lot of conversation around different corners about the new criminal laws having been brought in. But what is it that has been brought about, and whether it has made any meaningful impact or change, or we look after and we look forward to some change being brought about by these three laws. Let me confess that I am not an expert in these new criminal laws because we all have to learn. I was reading, and that's where I am going to share my part of the story, that whenever we talk about a new law, whatever we might have learned over a period of time, we need to unlearn that. So, मैं criminal law पढ़ती पढ़ाती रही हूँ 1989 से, to be very precise, and I am sure a majority of you may not have been even born at that point of time. So, whatever I had been reading with reference to criminal laws, the three criminal laws, now we have got a shift and there are new criminal laws. Since the session pertains to new criminal laws, what is it that there is that Indianization? The Indianization, as rightly pointed out by my two co-panelists, Professor Asad and Professor Vageshwari, is that we have brought in some change with reference to punishment. I'll just add on that when we talk about the theories of punishment, it's not only just expiation. We need to more focus on, alongside rehabilitation, on restoration. So when we talk about restoration, it is much, much wider in its scope when we talk about victim-centric approach. So what is it that we are restoring? And if we talk about, say, community service, or if we talk about compensation, or for that matter, we have the probation policy. How it is relating to Indian thought process? हम सबको पता है, हमारे हमेशा से पंचायतें रही हैं, घरों में घर में जो बड़े लोग थे उनके सामने जाके अपनी व्यथा बयान करते थे, आपस में विचार विमर्श होता था और सुलझाया जाता था, सॉल्यूशंस ढूंढे जाते थे, साथ चलाया जाता था, परिवार तभी इकट्ठे रहते थे, समाज तभी इकट्ठा रहता था. Now, when we are in a rights-based society, that's where the problem lies. The rights-based society coupled with our criminal laws, which were, as rightly pointed out by Professor Vageshwari, which were drafted and implemented by the British colonial rulers. For them, we were the subject. So they wanted to subjugate us. So they wanted to put us into discipline mode. So that was the force being used, so threatening being there, and that's where you will find even the police force is labeled and known as force. Police is not called as police service. हाँ, आपकी यूपीएससी में जरूर हम आईपीएस को सर्विस कहते हैं बाकी सर्विसेज के साथ, लेकिन the moment we talk about a police constable, what kind of feeling arises? मैं जो लॉ पढ़ती पढ़ाती हूँ और जो आप भी लॉ पढ़ते पढ़ाते हैं, अगर आपको भी कभी खुदा ना खासा पुलिस स्टेशन जाना पड़े तो कितना असहज हो जाते हैं हम, कितना मुश्किल होता. सो दैट इज व्हाई, बिकॉज वी हैव दैट फियर साइकोसिस क्रिएटेड इन अस बिकॉज ऑफ द वेरी फंक्शन ऑफ द पुलिस एजेंसी, बिकॉज दैट wields the baton, that wields force. It does not listen to, it is not just regulating, it is overpowering, it is determining as to what is right or what is wrong. Professor Asad did talk about FIR. There are a lot many components which have been brought in. The legal system, the new laws as such. We have huge change with reference to the timeline that has been fixed in our CRPC, the new Nagarik Suraksha Sanhita. As rightly pointed out by her, what is there in the name? नाम ही में सब कुछ है, अदरवाइज कुछ भी नहीं है. और ख़ासकर जब हम इंडियनाइजेशन की बात कर रहे हैं तो इंडियनाइजेशन का मतलब क्या है कि जैसे if I might give you that statement of our Honorable Prime Minister, rather the slogan wherein he says, think global, act local. So we need to learn from the best practices of others and other jurisdictions, but at the same time, we need to address the circumstances that exist in our backyard. तो जो भी कुछ हमारे घर में है, धरातल पे है, जो हमारे बैकयार्ड में, जो हमारे समाज में है, उसको एड्रेस करना है. We all understand there is that pendency of cases, huge backlog of cases, etc. But these new criminal laws are only trying to fix that. How do we reduce the timelines of criminal trial? And how do we ensure that justice is delivered and dispensed? So when we talk about justice, we all know it is hugely dependent on investigation and the outcome thereof. The moment, that's an added advantage, the moment we are talking about forensic evidence, the digital evidence, and rightly pointed out, and let me confess, I was not aware of this. Thank you very much, Mr. Gaurav, for informing that the Ministry of Electronics and IT has defined with reference to cyberspaces and forensic evidence and investigation a timeline. So that's where we are talking about speedier trial. So when we talk about Indianization of legal system, we have to understand that we are taking baby steps, and if we continue with these baby steps with the focus and direction, very shortly we would understand that we are no more talking about penalty, rather we are trying to ensure justice. That is the name Bharatiya Nyaya Sanhita, justice which is social, political, economic, and as we all understand that there are the vulnerable and the marginalized people who invariably languish within this criminal justice dispensation system. There's no denying the fact that with the new laws coming in, more focus would be given to these vulnerable groups when we talk about victims, that victims would also get justice. That's where restoration comes in. Victims getting a right to get the copies of all the documents alongside the accused. That's where we are talking about Indianization. So these small baby steps would certainly go a long way in ensuring that we are addressing the concerns which are there in our criminal justice system. Not to say that we are not going to learn from other jurisdictions, that we'll close our eyes with reference to whatever is happening in our surroundings, or for that matter, whatever scientific evolutions are happening. So with the technological advancement and evolution, we need to incorporate all those instrumentalities within our criminal justice system, so that when we say data protection rules, that is the need of the debate between privacy and the requirement of investigation. We need to address that. And I am sure with the passage of time, we would be able to understand and bring about an interface wherein we resolve the concerns and the bottlenecks which are there in the entire criminal justice system. And towards the end, understanding and realizing that time is short, a very grand acceptance of the fact and acknowledgement of the fact that there are institutions which have started thinking on the lines of Indianizing legal system, and this is a step of B.R. Ambedkar University. Hats off to you, and I believe more other universities would also fall in place. Just reminding you that last year, Faculty of Law in April started off with the very first conference on the theme that we need to incorporate local languages in the Indian legal system. And we had a 2 days national conference wherein different stakeholders from different streams and wherein a couple of our colleagues participated. We had the very first on Bharatiya jurisprudence, and we are looking forward to continuing that legacy in Faculty of Law. And very soon we will be informing you that there is another series coming in. Thank you very much, and we look forward to your support in the endeavor to bring about indigenization of our Indian legal system. Thank you very much.
Thank you so much, Professor, for your enlightening and inspiring address. Your words have added immense value to our understanding of the subject and have offered strong academic perspective on today's discussion. Ladies and gentlemen, we now take the honor of welcoming a distinguished guest whose presence adds immense value to this gathering. A seasoned professional known for his clarity, conviction, and commitment to the legal and administrative framework. Sir, we are delighted to have you. We may now please request Shri Inderjeet Mehta, esteemed member of Haryana State Law Commission, as chair for this national conference. Sir has been actively contributing to the shaping of progressive legal frameworks, and his insights today will surely help us better understand. May I now invite Shri Inderjeet Mehta to address this gathering.
Since morning, I have been here and listening to what the excellent speakers have been speaking before you. Before I start, for the first time in my life, I am going to utter some words. Honorable Mrs. Justice Meenakshi I. Mehta. Before she became Meenakshi Mehta, she was Meenakshi Girdhar, and after she married me, she took my name as Mehta, but she has been very kind and grateful for me that when after marriage she changed her name, she added my name with her, and now her full name is Meenakshi Inderjeet Mehta. And I am really grateful to her for adding my name with her name, and I take pride in that. co-panelist on the dais, distinguished guest in the first two rows, my sons and daughters, students of law. I am seeing the anxiety on the face of the Vice Chancellor, but I won't take much time because there is paucity of time. When you speak after 3 or 4 panelists have spoken before you and those who are so well read and so well accomplished, what I find is my predicament is that whatsoever I had noted down for last 2 days to speak before you, the 90% has already been spoken by them. Anyhow, this is the situation you have to handle in life. When I was sitting there, both the sides, 3 of the panelists are doctors. So when I was sitting amongst between 2 doctors, I didn't allow myself to feel the feeling of a patient. So I kept my tempo on because when you are surrounded by doctors, anyhow, the question is that after the new laws have been implemented, what laws have been implemented, those have been explained this morning. The question is how we can yield the results if they have been implemented. What are the impediments? What are the challenges we have to cope up with to achieve the result for which these laws have been enacted? You, all the students who are here, in criminal law, now as per BNSS, which has replaced the erstwhile Code of Criminal Procedure, Section 173 is of vital importance, and all of you law students must go through it very, very carefully whenever you happen to read that particular section, because this is the section which set the law in motion. Even if you are not a victim, being informant, you can set the law in motion. With the advent of technology, as has been detailed by Mr. Gaurav Gupta in his address before you, now if you have to lodge a report with the police, through email you can send the same. Within 3 days, that has to be got signed by the person who is sending it to the police station concerned. Now when you read the section 173, I have brought this book with me. What I intend to impress upon is, because since morning I have been saying that the students should be taught or should be spoken to in their language and how it can be helpful to them. Everybody knows when you study section 173, there a provision has been added that if the information has been given by a woman whom an offence under section 64 to 71 and 79, those offences are related to sexual offences, then such information is to be recorded by a woman police officer. Please read it whenever you read it, or any woman officer, for the people who teach the law, or ultimately I think this point will be debated over the judgment given by some time, that who are the person who are included in the definition of woman officer. Now suppose some offence has been committed against a woman, some sexual offence has been committed. She is staying in an area where she cannot reach to the police station. She is from that strata of society where she is not having any cell phone with her. but she is living in an area where I think that some education officer, some SMO, some CMO, who's a woman officer. In my opinion, that victim can lodge a report with that woman officer. This point is to be debated, but is my opinion, because in the act it has been written that any woman officer. Now with the passage of time we will come to know that who are the person who would be included in this definition of woman officer. Now again when you go through this section, then it is regarding the victim who are temporarily or permanently, mentally or physically disabled. Then such information shall be recorded by a police officer. I fail to understand that why here a woman police officer has not been mentioned, especially when the victim is incapacitated. Though some cover has been provided to her that the same would be recorded at her residence in the presence of an interpreter or a special educator. But there may be a situation that an incapacitated victim is staying in the house alone, and a male police officer goes, and if he goes with a male interpreter, then the very purpose of incorporating this section, I fail to understand. This point will be also ultimately clarified, that whether there has been omission on the part of the legislation not to mention a woman officer. This, whenever you study law, I just want to tell you all the students, whenever you study law, read this provision again and again. Law is, though it's a codified common sense, but it has to be pondered over again and again. More you read the law, more you will become what are the complications or what are the intricacies of the law. As Mr. Dr. Asad rightly pointed out, that under section 173, for the offences which are punishable for a period of 3 years but less than 7 years, an option of inquiry has been given. Rightly pointed by Dr. Azad that this is contrary to the Supreme Court verdict in Lalita Kumari case in 2013, where a duty has been cast upon the police officer to lodge the report irrespective of the fact. Ultimately, you may discharge it to the police, may submit a discharge report, but it is at the variance of the same. But if you read this provision again further, that if you conduct an inquiry, if you find a prima facie case, so within 14 days you have to complete the same. And if there is a prima facie case, then you can lodge the FIR. But there is no clarity that there is no prima facie case and an FIR is not registered, then what will you do? Because the next section doesn't say anything about 176.3, it simply says about 176.1. where the case was initially supposed to be registered with the police. So my request to you all is that whenever you study law in a way to how to interpret it, and ultimately you may reform any law, you may reform anything, unless until the person who is implementing it, unless the judge who is deciding the case, he is not sensitive to the case, he is not honest to his duty, he is not sincere to his duty, the change in law doesn't affect that much unless until we are that sincere to it. For that, you have to be very sensitive and compassion. I did my duty as a judicial officer for a long 34 years. I did criminal trial as a magistrate, I did criminal trial as a district and session judge. After I superannuated in 2018, thereafter I have been claim commissioner Haryana, where I dealt with cases relating to this JAT agitation. This has happened in this area. Thereafter I also served as a judicial member in Rera Appellate Tribunal Haryana, and at present I am working as this member as Haryana State Law Commission. not taking much time, I would like to share with you only my experience, which perhaps will tell you that how compassion and sensitivity, either with the police or with the advocate or with the judge, matters in the dispensation of justice. When I was district and session judge at Faridabad, I was doing a trial where a husband was facing trial for the death of his wife on account of abetment of suicide. The lady had committed suicide because of the behavior of the husband. Ultimately, when the evidence was led, I held that man guilty, and after 2 days, the case was adjourned for awarding sentence to him. Generally, as per my own practice or as district and session judges, what we have been doing is that we just used to give sentence up to 5 years or 7 years, though it was with the discretion of the session judge that from 3 years to 7 years he can put the man behind bar. I had already decided that at least I will put this man behind for 7 years. But when on the day this sentence was to be awarded, he came in the courtroom with his 2 daughters. One was aged about 12 years, one was aged about 15 years. Unfortunately, there were no grandparents on either side of those 2 young girls or young 2 daughters of that person. Immediately after seeing them, I was reminded of my daughter, who at that time perhaps was of the same age. And that is the sensitivity, how you see it. What I thought was that if I put this man behind for 7 years at this stage, he will go behind the bar. There is nobody else on the earth to look after these 2 young daughters, 12 and 15 years of age. What will happen to them? You know what is happening in the society. Where these 2 young daughters will go, where they will go. Since I had the discretion, so I awarded him sentence for 3 years, and I asked his counsel that you move an application for releasing him on bail, because law provides it. If a session judge or a magistrate sentences someone for 3 years imprisonment, that then he can release him on bail, enable him to make an appeal to the higher court. So I asked his counsel, please move an application, I will release him on bail. If ultimately his imprisonment to be announced by the high court, it will be announced after 5, 6, 7, 8 years, because when matter will be taken over. But I think in between these 5 to 7 years, the future of these 2 daughters would be safe. And I still derive immense satisfaction from the decision, because in that case I simply didn't decide the case. I did justice to those 2 young daughters who could not have been left to the mercy of the society which is prevailing to them. Anyhow, what I had said earlier was that I am left only with 10% of the speech which I prepared, and it always happens in my life. Whenever I go with a prepared speech, I am not able to read it fully. The same has happened again today. Though this legislation has been made, but the path to realize the goal for which has been made is really difficult, and I have put some suggestions that how these some impediments which are there, how we can achieve that. The number one problem is of the capacity constraints. Police forces, especially at the district level, are often under-resourced and under-trained. The forensic infrastructure remains less in many states. When you have changed the law, but who is to implement the law? Law is to implement by the police at the lowest level. They have to be trained. That workforce has to be trained. Then the result would be achieved. Our DGP, who has been a distinguished police officer, he must be knowing that the police official, they have so many other things to do then the investigation and press investigation is their last agenda. Because of the work constraint, not because they don't want to do it. Because the culture is such. Unless until we change the atmosphere of the working of the police, and they don't have the time to spend the time on investigation, and they don't have the know-how of the forensic changes or the forensic changes which are made in that, so how we can achieve the result? Number two, जुडिशल ब्लॉक लोग हैं हमारे यहाँ बहुत ज़्यादा प्रोसीजरल, उसमें अब काफ़ी चेंजेस लाने की भी कोशिश में की गई है. I think we have to see that whether we are able to achieve that purpose or not. Awareness and training, judges, prosecutors, defense counsel, investigations, they require extensive training for that. Because you have made the law, but you have to make all the stakeholders to be aware of that and how to implement them. Then there is a digital divide in this society. In urban area, in rural area, there is lot of difference about the knowledge of digital world. So that with the passage of time, I think there will be. And there are so many other things I can go and narrate with my experience of 34 as judicial officer, but because of the paucity of the time and the anxiety on the face of the Vice Chancellor, so I am seeking, I express my gratitude to all of you who have given me an opportunity and me, and thank you very much.
Thank you so much, sir, for your insightful and thought-provoking address. Your valuable perspectives on legal reforms and Indianization of our justice system have truly enriched this session.
We are extremely apologetic for such a tight time constraint. I'm sure everyone wanted to hear more. We are privileged to have whatever we have. Thank you so much. Ladies and gentlemen, as we near the conclusion of this enlightening session, we take a moment to express our deepest gratitude to the distinguished individuals who have graced us with their wisdom, expertise, and invaluable presence. We now begin with the felicitation ceremony to honor our esteemed dignitaries for gracing us with their presence. With great reverence, I would request the Vice Chancellor of our university to felicitate our chairperson for this session, Shri Inderjeet Mehta, member of the Haryana State Law Commission. May I would further request Dr. Ashok Kumar to felicitate our co-chairperson of the session, Professor Dr. Anju Vali Tikoo, Faculty of Law, University of Delhi. I humbly invite Honorable Vice Chancellor, Dr. Ashok Kumar, to felicitate our distinguished guest, Mr. Gaurav Gupta, Director, Cybersecurity Division, Ministry of Electronics and IT, Government of India. Further, I would like to call upon Honorable Vice Chancellor, Dr. Ashok Kumar, to felicitate our Professor Vageshwari Deswal,
Professor, Faculty of Law, University of Delhi. And lastly, I would like to kindly invite Honorable Vice Chancellor, Dr. Ashok Kumar, to felicitate Professor Dr. Asad Malik, Faculty of Law, Jamia Millia Islamia.
We now welcome Dr. Balvinder Kaur, Associate Professor, Dr. B.R. Ambedkar, National Law University, to deliver the vote of thanks.
Namaskar everyone. I am honored and privileged to extend the vote of thanks for technical session 2 of the National Conference on the Indianization of the Legal System, focused on the crucial theme of new criminal laws, organized by Dr. B.R. Ambedkar National Law University, Sonipat. First and foremost, I express my deepest gratitude to our session chair, Shri Inderjeet Mehta ji, a member Haryana State Law Commission, for gracing the occasion with his presence and insightful observation. Sir, your wisdom has greatly enriched today's discourse. I sincerely thank our co-chair, the Professor Dr. Anju Vali Tikoo Madam, Dean Faculty of Law, University of Delhi, for valuable perspectives and thoughtful contribution to the session. Our heartfelt appreciation, a special word of thanks to our distinguished special guest, Professor Dr. Vageshwari Deswal Madam, Faculty of Law, University of Delhi, Mr. Gaurav Gupta, Director, Cyber Security Division, Ministry of Electronics and IT, Government of India, and Professor Dr. Asad Malik, Sir, Faculty of Law, Jamia Millia Islamia, Delhi. I also thank Honorable Vice Chancellor, Sir, Shri Ashok Kumar ji, and Registrar and Conference Director, Shri Ashutosh Mishra ji, delegates, faculty member, and students for their active participation and enthusiasm throughout the session. Finally, to all attendees, legal professionals, media personnel, your presence here today reflects a shared commitment to justice and the rule of law. Let us move forward with the collective resolve to uphold the spirit of this new legislation in both letter and spirit. Thank you to all. Jai Hind.
Thank you, ma'am. With heartfelt gratitude, we bring this intellectually stimulating session to a close. The insights shared by our esteemed speakers have not only deepened our understanding, but also inspired us to think critically about the future of criminal justice in India. With this, we conclude technical session 2. Now, I would like to request everyone to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय 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 जय